Hi, it's Roland Jones, and thanks for watching. This is a slideshow on preference clawbacks in the staffing industry. Staffing industry is probably the number one industry that gets sued for preferences. So I decided to make a slideshow focusing just on staffing. The way I'm going to do it is just go through a number of cases where the defendant or the debtor was in the staffing industry, and just to illustrate the issues that can come up in the context of a preference case, and hopefully that'll give you some guidance in dealing with preference cases if you're a defendant providing staff to a debtor. Okay, I'm going to talk about two things. First, preferential transfers. That's most of what I'm going to talk about, but I'm also going to talk about fraudulent conveyance transfers, which is a different topic, and they're two very different kinds of bankruptcy lawsuits. But first I'm going to talk about preferences. First case I'm going to talk about is a hospital case where there's a staffing company providing hospital staff. And it's a pretty recent case from New Jersey, and gives an example of something that can happen in the context of the staffing business. Okay, so the hospital entered into an agreement with Onward, the staffing company, and breached the agreement. And Onward sued in state court, and the hospital defaulted, and so Onward got a default judgment. After the default judgment was entered, a sheriff put a lien on the hospital's assets, and then there was a settlement, and a consent order was entered, and part of it was a lump sum, and then the other part was payment over time. So before the first payment was due, of course, the hospital filed for bankruptcy. Trustee was appointed, and trustee filed a motion for summary judgment to find that whatever was paid pursuant to the settlement was a preference, since it was paid within 90 days of the bankruptcy filing. Well, the defendant argued that at the time of the transfer, it had a bank a levy on the debtor's assets in that bank account. So the defendant was arguing, hey, we're a secured creditor. And as we've seen before, a secured creditor is basically a fully secured creditor is basically immune from a preference lawsuit. Why? Because a secured creditor would be paid the same amount before the bankruptcy case as it would be after the bankruptcy case. Why? Because it's secured. So it has a right to get paid out of its collateral. If it's fully secured, it's not going to be paid more prior to the bankruptcy. And that's one of the elements the plaintiff has to prove, that it would have been paid more. And so here the defendant is saying, hey, we had a lien at that time, that's a complete defense. The defendant also made a couple of other arguments. One is that the wire transfer of the funds was not transfer property of the estate. It didn't belong to the debtor anymore. Once the bank account was liened on, no longer belonged to the debtor. So it wasn't property of the estate. And then the second argument is that the wire transfer was not made on account of an antecedent debt. Why? Because the invoices were settled pursuant to a settlement agreement prior to the wire. So there wasn't any debt. Those invoices were not being paid anymore. This is the relevant code section, and the different arguments, different defenses, 547B, and then I highlighted the arguments that are being made. Court basically said, no dice. The levy that was placed on the bank account itself can be avoided by is avoidable by the trustee as a preference, so that it doesn't grant secured status. In that although the debtor may not have had a possessory interest, it did have an interest that could be recovered once the levy was avoided. So the court threw out the main argument, and the wire transfer was transfer of property to the estate, since the trustee could avoid the levy. And then as far as the antecedent debt issue, the court basically said the debt arose with the invoice. It's not really relevant whether the debt was later settled. It didn't wipe out the debt. The debt was created at the time of the invoice. Also, the court found that the debtor was clearly insolvent at the time of the wire transfer, so that once the wire transfer was avoided and the lien was avoided, the defendant would be just in a position of another unsecured creditor, and since it was paid 100 cents on the dollar, the court also found that it was paid more than it would have been paid in a hypothetical bankruptcy case, and in this bankruptcy case. So what's the takeaway? I think the takeaway is, because you have a lien prior to the bankruptcy case that may temporarily turn you into a secured creditor, it's not going to help you if the lien was if the lien is subject to avoidance. It's not going to help to turn you into a secured creditor so that you can make secured creditor arguments. What's interesting here is that apparently the defendant didn't make any other arguments like ordinary course or any of the other standard arguments. I guess it was leaning on this argument because no other arguments were addressed and summary judgment was granted. So I think the other lesson is make all the arguments you can. You never know which one is going to win or lose, for that matter. This is another fairly recent example of a staffing industry case in the context of preference litigation. Fairly recent case, New York, 2006. This is at the district court level. This is an appeal from bankruptcy court. The appellant was the defendant. Pro Staff provided temporary and permanent workers to Authentic Fitness Corporation, and it worked like any other staffing companies. Pro Staff sent workers over there, and AFC paid Pro Staff. So AFC got paid by a few wires right before the bankruptcy filing, 3 days prior, and AFC sued to recover those as preferential payments. $452K and change were for pre-petition services, and $79K and change were characterized by AFC as an overpayment or a fraudulent conveyance. The bankruptcy court granted granted summary judgment for AFC, and Pro Staff appealed. Of course, the debtor made its arguments that these were all preferences and that there was no new value. And Pro Staff made a few arguments. One is that the so-called overpayment was really just segregated withholding taxes, and that the argument they were withholding taxes, and these were trust funds they were holding in trust to pay the IRS. So they should not be available. They did not belong either to AFC or to Pro Staff, were just being held in trust. So that's one argument. The other argument is an argument that is often made in staffing cases, and the argument is, hey, we're just a conduit. You paid us, we paid the people that we provided as staff, and we're just the middleman here. It's called the mere conduit argument, or the objection to the label of initial transferee, which is usually found on boilerplate in every complaint. You're the initial transferee. So they're saying, well, we're not the so-called initial transferee. We're just a conduit for these funds. The last argument they made is that we provided services right before the bankruptcy, between the time of the wires and the bankruptcy, and these services should be, we should be allowed to set off the value of these services as new value. So a lot of issues here. Were all these transfers in interest of the debtor in property, including the so-called IRS withholding funds? Was the defendant an initial transferee or not? Was new value provided or not? Also, the defendant made an ordinary course argument, and so did that apply or not? So this is the statute, 547B. This is, at the beginning of the statute, it's recited that the trustee may avoid any transfer of an interest of the debtor in property. And so the defendant is saying, well, you know, it's not an interest, at least not the trust funds or alleged trust funds. New value is provided, and ordinary course. Well, as to the withholding taxes, the court refused to agree with the appellant that these were not property of the estate. And basically the court said, hey, AFC paid you, and you did whatever you had to do. You had to withhold taxes or not, but that's not AFC's problem. And you're just a vendor to AFC. AFC didn't have to withhold any taxes. So they're on your payroll, not AFC's payroll, and so these were not trust fund taxes. As to this conduit argument, the court rejected it as well. And basically, and this happens very, very often with this argument, is that the court basically held that this was not a conduit, it was a reimbursement. Why? Because Pro Staff had paid did the right thing. It paid it paid the staffers first, and then it was paid by the debtor, and so it wasn't a situation where they were a conduit for anything. In fact, they kept the money. Why? Because they already paid the staffers. They're not going to transfer the money to the staffers that they received from the debtor, because the staffers were already paid. So it took away their argument that they were a conduit. If the folks that they supplied to AFC had not been paid, and then they received payment, and then they transferred the payment, that's a much stronger argument, and there is case law to support that. But if you pay the staff first, it's going to knock out your conduit argument. I'm not saying you have a guaranteed conduit argument if you don't pay them first, but it's something to think about. As to the new value defense, the court found that Pro Staff just failed to indicate exactly what work was done. So it declined to agree with that argument as well. Also, there was no ordinary course. There was no backing for any ordinary course defense, apparently, so the court denied that as well. You know, what's important? What's the takeaway here? Takeaway here is this conduit argument is typically not going to work in a situation like this. In a situation where the staffing company pays the staff and then seeks reimbursement from the debtor, the conduit argument is probably not going to work. Also, the trust fund argument, at least it's not going to work in this court. I don't know if it's going to work anywhere else. That's actually the first time I've seen that argument. But it's certainly not going to work here. And then the other takeaway is if you're gonna use the new value defense or the ordinary course defense, you've got to give a rationale for these defenses. You have to show exactly when the new value was transferred, when the services were rendered that were not paid for. In the 360 Networks case, the defendant in the preference action was an entity that provided relocation services to employees. So the company was relocating, and the defendant was in charge of distributing relocation benefits. Not exactly a staffing company, but I thought it was related enough to include it in the slideshow because some of the issues are similar, and the defenses are similar. So the debtor paid the this provider of relocation administration a rather large sum prior to the bankruptcy case, and sought to recover it with a preference lawsuit. Of course, the defendant argued that it was a mere conduit. It's just paying out benefits that were paid to the entity by the debtor, paying out relocation benefits to the debtor's employees, not its own employees. So it's not a staffing company. These were the debtor's employees. So just paying out money. How can this not be a conduit? The debtor argued that this was just payment of a contract, and they're just a vendor like any other vendor, and that there wasn't any new value. The defendant argued that it also had contemporaneous exchange for new value defense. And this was an interesting argument and could be relevant to a staffing company. The defendant basically argued that if it hadn't done its work, it hadn't provided relocation benefits, hadn't processed that, then the employees would have walked off the job or they wouldn't have relocated. Because it did do its job, the debtor got a contemporaneous benefit of the employees relocating. The argument is not that the entity itself, the defendant, provided contemporaneous exchange of new value, but because of its actions, a third party, the employees, provided the contemporaneous exchange for new value. So, was it a mere conduit? Did the employees' work constitute a contemporaneous exchange? Or did the payments, the transfers, were they made in payment of a contemporaneous exchange for new value? This is the statute. Well, the court shot down the mere conduit defense, and the rationale is that the benefits were paid prior to being reimbursed by the debtor, and therefore they're not a conduit. They had a debt, the debtor paid it, and that's that. That's often the case if payments are made prior, so it's an important consideration, something to think about if it looks like a customer intends to file for bankruptcy. The other issue is that the defendant had complete dominion and control over the funds, especially since it already paid the funds. But the other issue that is sometimes raised is that even if the defendant had not paid, let's say, had not paid the relocation benefits yet, but it accepted these payments from the debtor and still had the complete legal control to do whatever it wanted to with the funds, then you could argue that it wasn't a conduit. But obviously, if it hadn't paid the funds first and then transferred, there are more arguments available. There's an agency argument, a trust argument. The case is much more powerful, so it's something to keep in mind. Now, as far as the contemporaneous exchange issue, the court denied summary judgment for both sides. So the court basically said, this defense might be available, even though it was the employees, a third party, that provided the new value, not not the not the defendant. Basically, just the record was not adequate, and therefore more discovery was probably needed, and perhaps a trial or another motion. So I think the main takeaway from this case is that conduit argument is much more likely to succeed if it's not a situation where the defendant is being reimbursed. And second, new value can be provided by third parties. For example, the independent contractors of a staffing company. It does not have to be provided by the staffing company. If the staffing company provided access to independent contractors under certain circumstances, this might be considered new value, contemporaneous exchange of new value. Okay, I'm going to switch gears a little bit and talk about the ordinary course of business defense that most people know about in relation to staff issues. Okay, the first case is Prudential Real Estate. Actually, this is an appeal. Prudential was the defendant, and Prudential provided relocation services. Birch was the name of the trustee, and this was an airline that they were dealing with. This case is 2015 out of Delaware. Well, what happened here is that Prudential was providing, I guess they were moving, and Prudential was providing various services to its to the airline's employees. This was a small private airline. And what happened here is that during the first year and a half, the debtor at that time, of course, wasn't a debtor. Eclipse paid on time and within terms. And then towards the end of 2007, they started to fall more and more behind. And Prudential, being a good creditor, was alert and put them on billing review, whatever that meant to them internally. But basically, was pressuring the debtor to accept stricter terms, and was more on top of payment issues. So this was the first payment plan that Prudential required the debtor to be a part of. So the debtor did better in its payment terms, and Prudential removed it from the first payment plan. I'm assuming gave it better terms. Then a few months later, the airline again ran into trouble and again slowed up on its billing. And then in the 90 days, of course, it filed for bankruptcy eventually, and then the 90 days prior to that, made payments to Prudential, and Prudential sued, and in the bankruptcy court level, the judge found for judgment for the trustee, for the debtor, and then there was an appeal. Well, the defendant argued on appeal that the bankruptcy court erred by finding that faster payments during the preference period of 40% improvement supported a finding that these transfers were not in the ordinary course of business. By the way, I get that a lot. A lot of people say to me, "Hey, we got paid faster. How could that? It's more understandable to say, oh, we got paid super late, and that was out of the ordinary course. But if we got paid faster, how could that be? How could that be a bad thing? How could that be a bad thing?" And the fact is that any change is a bad thing, and faster can be a sign of collection pressure. Well, the defendant argued that it had just continued with the past practice. In other words, the argument by Prudential was, hey, this has happened in the past. In the past, we tightened up on the airline because they were making slower payments, and then we loosened up when they got better, and now we're tightening up again. So it's business as usual. So, of course, that's the issue. Was it in the ordinary, were the payments in the ordinary course because they were a lot faster? Is that enough to take it out of the ordinary course? Or what? This is the relevant statute. Well, the court rejected Prudential's arguments completely. And basically the court, the way the court looked at it was that, yes, in the past, Prudential had applied stricter terms, but for most of the time, they didn't. Most of the time, the debtor paid according to terms. And the comparison should be between when the debtor was paying pursuant to terms and when it was not, and when it was paying differently. And during the preference period, it was paying differently. It wasn't paying pursuant to terms. And the judge treated the collection pressure that was applied previously not as an example of ordinary course conduct, but as another anomaly, and considered the collection pressure during the preference period as an anomaly. Well, what's interesting about this case is that I think the takeaway in this case is that prior conduct does not necessarily make conduct during the preference period ordinary. And the court's going to take a look at how pervasive the earlier conduct was. In this situation, Prudential applied collection pressure once before by making the debtor agree to a payment plan, but that's it. It wasn't a regular pattern. And then just because, and then it occurred again just because the debtor again applied collection pressure during the preference period. It was not enough of a pattern to show ordinariness. Instead, the court saw that most of the time the debtor paid according to terms, and focused on that as being the baseline, and then finding that the very early payments, the dramatically earlier payments during the preference period with collection pressure, was far different, and took it out of the ordinary course. This is a pretty recent Delaware bankruptcy case having to do with a staffing provider of consultants. Defendant's called Vector Consulting. It's in the business of providing temporary IT professionals, consultants. And the debtor was American Home Mortgage Holdings. As you can figure out, this was around the time of the Great Recession, and this was a mortgage broker. So, you know, this is a relatively small case, $29,920 in the preference period, and I'm sure neither party was relishing the concept of taking these to trial. Both moved for summary judgment. Facts of the case: during the historical period, payments ranged from $4,675 to $12,240, and the payments, the days outstanding, the time that the payment was made after invoice was between 7 and 67 days. During the preference period, the payments were between $5,440 and $12,920. The reason this is important is because it's one of the elements of ordinariness. In other words, if the payments were typically $5,000 during, you know, or all $5,000 or around that number during the historical period, and then all of a sudden they cut one check for $50,000 during the preference period, then there's an argument that can be made that the amount of the check is out of the ordinary. It's just another argument that the plaintiff can try to make that something unusual and not business as usual in the preference period. Anyway, if you notice, the payments were made within range. So between 7 and 67 days, historical between 34 and 62 in the preference period. So all payments were made within the same range as payments during the historical period. And as we're going to see in a second, this is taken very seriously in Delaware. Well, the committee argued, the defendant made a range argument, and so the committee had to find something else. And what they did is compare the averages, and they found that the average increased from 24.7 days during the historical period to 57.4 days during the preference period. So all ordinary or most ordinary course litigations or disputes have the same similar pattern. The defendant is going to pick something that works for the defendant, is going to pick an aspect of the conduct of the parties that's similar during the historical period and the preference period. In this case, all payments were within range, Your Honor. So that's the argument. That's what they have. And then the plaintiff is going to look for things that are dissimilar between the two periods. Here, it found that the averages were different, so it's going to make that argument. I know it's not making other arguments, so this is probably the best it was able to come up with. So the defendant argued that the timing of the payments sufficiently similar, not so dissimilar as to take it out of the ordinary course, especially given the fact that the payments were within range. So the within range argument is basically, hey, it's all happened before. Nothing unusual here. Payments were within range. So there's nothing out of the ordinary here. It doesn't matter if the averages were higher during the preference period. They were still within range. This happened before. They paid that late before in the historical period. Defendant also argued that since it provided consulting services subsequent to one of the transfers, it was able to set off the value of those consulting services. So were the transfers made in the ordinary course? But also, the second issue, which is not on the slide, is whether there's a new value defense. That's the statute, 547C2. C2A, ordinary course of business or financial affairs between the parties. C2B, ordinary business terms, which has been interpreted to mean did it comport with the industry standard? Did the transfers and the way they were paid, did the conduct of the party, was it ordinary in the business, in the industry? And that's the new value section, 547C4. Well, the court found that this was a pretty short relationship. It was only 8 months, the entire relationship, so that really the pre-preference period was only 5 months. And this is usually problematic for a defendant. When I see that, I know it's going to be a problem. Typical historical period is a year or two. And the argument there is that it's not enough of a period to make an adequate comparison or make an adequate determination of what's ordinary. It's just not long enough. It's only 5 months. At a time when 5 months later or 8 months later they filed the bankruptcy, so it may have been an unusual time. So in cases like this, you want to also show an industry standard, which is the other prong. Since the first prong is comparing how the parties did business, but since it's hard to make a comparison because they didn't do business very long, so you want to also prove the second prong, which the defendant also provided evidence for, and the court found that it was sufficient evidence to show ordinariness. The court found that noted that payments were within range, and also took a look at the industry standard, and the industry standard basically found that in the IT staffing industry, payments were usually made after the due date, here 30 days. Here they were made after the due date, and the court found that to be sufficient for purposes of the industry standard. And the court found that there was some new value. The value of the consulting services was found to be $5,440, and that was, the defendant was able to set that off, but it didn't really need the new value defense because it already had won on the ordinary course defense. So what's important here to take away? Well, one of the things that's important is that circuits and courts and bankruptcy courts really differ on what's ordinary course. In Delaware, the bankruptcy courts place a lot of emphasis on the range defense, and somewhere else you're not going to have that leeway. Also here, the industry standard was found to be fairly easy to meet. You may not have that in another court, whether this district, circuit, or another circuit. So again, what's difficult for a lawyer here is these cases are hard to predict, because this case could have definitely gone another way, in my opinion, in another circuit. Maybe even with another judge. When I said other judge, I meant another judge in the same circuit, maybe in the same district. It's not that easy to predict these cases because each one is different and has different wrinkles, and the law, the basic ordinary course law states that it's an intensive factual determination on a case-by-case basis. So anyway, the conclusion is, another takeaway is when there's a short history, this court found that the defendant is going to have to fill that up with the second prong, in which case, and in this case, the court found that that was successfully done. Also, that late payments do not preclude a finding of ordinary course. In fact, pattern of late payments here, there were late payments between the parties, and the industry standards seem to imply that payments were usually late in supplying IT professionals. So that's all I have to say about this one. This is another ordinary course type case in the context of another staffing company. This is a 2011 case and a bankruptcy level case in Missouri. The trustee argued in this case that there were unusually large amounts of payments made in the preference period as compared to the base period. The judge responded by saying, hey, they did more business. So what? You know, how is that relevant to ordinary course? They pretty much dismissed that. The defendant basically said in the comparison period, 90% of the transactions were between 30 and 60 days. And in the preference period, they were paid between 30 and 60 days. So it's just a classic range comparison analysis. So again, the question is, were the payments in the ordinary course or not? And again, the same statute. The court agreed and found ordinary course. This is another ordinary course defense in the staffing business, this time a provider of relocation services to employees. Relocation services seem to be sued a lot for preferences, probably because the debtor is relocating maybe to less expensive premises or selling buildings or whatever, but it seems to be a sign of financial distress, certainly sometimes, because a lot of these guys are sued for preferences, relocation services. Anyway, this is a bankruptcy, Southern District of New York, hometown case, 2005. Well, the 360 Networks provided telecommunications services, and like I said before, the defendant provided relocation services, and the defendant would administer the employee relocation benefits plan. Under the agreement, the defendant could not make independent determinations as to benefits, so it had limited discretion. It also dealt with subcontractors, and this was not raised as a defense, but I'll talk about that in a second. So, in other words, the debtor it acted essentially as an agent or a pass-through between the debtor and other vendors. I may have spoken about this before. At any rate, terms of the agreement provided that the defendant could reimburse people first before being paid. So in other words, the defendant could pay people first and then be reimbursed by the debtor. That's a better way of saying it. At any rate, during the 90 days, the defendant was paid a substantial sum, and a lot of that was apparently reimbursement for payments that the defendant had already paid out. So the only word I could think of there is ouch. I'm going to talk a little bit about what's called the conduit defense, and what I'm going to say about that is typically this looks like a conduit defense. In other words, the argument is, Your Honor, we're just a pass-through. The money came to us, but we paid it right out to vendors. That can work. There's a long line of cases addressing that issue. The problem is if the defendant pays the vendors first and then is reimbursed, then typically that defense doesn't work. The defense looks at the control over the funds. If the defendant was paid and then had to pay these other folks, had an obligation, a legal obligation, then that's recognized more as a conduit. I don't think it's very fair, but that's how the courts came down. Anyway, that's probably why that defense was not used here. So the debtors argued that the payments were not in the ordinary course. Why? Because the defendant threatened to stop work. If you don't pay us, obviously they were late, we're not going to work. It's normal, it's reasonable. In fact, the defendant officer in charge of collections would not be doing their job. Would not really be acting appropriately as business people if they didn't try to get paid if they were late, and it's just a normal method of trying to get paid. But in the context of the preference laws, it's going to be a problem because it's obvious collection pressure, and unless you did that consistently, probably not in the historical period, it's going to take you out of the ordinary course because it's collection pressure and not ordinary to the relationship. And it's fairly typical. Why? Because the company's about to go bankrupt. So a lot of times they're very slow in paying. A lot of times vendors are refusing to continue work. The problem is, the irony is, when they do that, they're destroying their ordinary course defense. But maybe it's better to get paid and then worry about getting sued for a preference later anyway. Well, that's the issue. 547C, we've seen that. You have that memorized by now. Well, this was like shooting fish in a barrel. I think probably the plaintiff was thinking that. This is serious collection pressure, and it was not ordinary. It was found not to be in the ordinary course because it was a pressure tactic, and not something that was normally done in the relationship. Summary judgment for the debtor. Ouch. Ouch again. Takeaway here. Payments made as a consequence of collection pressure, not usually in the ordinary course, not always not in the ordinary course. Sometimes this is how the parties did business. I've seen everything by now, and one of the situations is, hey, for the last 2 years prior to the preference period, every 2 weeks they would call and threaten to stop doing business. So, and then they did the same thing in the preference period. It's ordinary course. That's how they did business. All right, I'm going to talk about the new value defense in the context of staffing cases. This is another staffing company case, and it addresses the earth-shaking question of whether the new value defense can be used to set off prior transfers if the new value was paid for after the bankruptcy case. So this is very, very exciting stuff for bankruptcy lawyers, and if you're involved. For everybody else, probably not too exciting. Debtor was Friedman's jewelry store. Defendant, here the appellee, was Roth Staffing Companies, provided staff. Received preferential or alleged preferential transfers of $81,000 and change in the preference period. But Roth said, we provided staffing services after we got that transfer, subsequent to the transfer, and we were not paid for that during the preference period. So we should be able to set off the value of that against the prior transfer. So we pay nothing. What's interesting here is that the debtor filed a motion after the bankruptcy seeking authority to pay its employees and independent contractors pre-petition wages, compensation, and related benefits. The court granted the motion, and pursuant to the motion, the staff that Roth provided was paid pursuant to that wage order. So after the bankruptcy case, the debtor paid $72,412.71. That is part of the $100,000 and change Roth claimed it was owed pre-petition, before the bankruptcy. So just to recap, Roth is saying, we provided $100,000 and change worth of services. This is new value. It's subsequent to transfers. It's not paid. We should be able to set that off. And the debtor is saying, well, look, you got paid after the bankruptcy for at least a substantial part of that. You can't use that anymore. The whole argument here is that these services, there are two arguments here. One argument is the debtor's argument, and the debtor is arguing, well, the purpose of the new value defense is as follows. Transfer comes in, it's preferential, these guys are being preferred, but instead of making them give back the transfer, we're going to take into consideration that they replenish the estate with an equal amount. So unsecured creditors are not being hurt. Why? These guys are being paid 100 cents on the dollar, but they're also replenishing the estate because they provided staffing services of $100,000 and they didn't get paid for them, so they're replenishing. So if they got paid for them later, then they're not replenishing the estate anymore. Then they're getting a windfall. They're getting to keep the preference, and they get paid. So that's not right. That's what the debtor is arguing. The defendant is arguing, look at the bankruptcy code, do an analysis, and you'll see that the drafters meant that the new value can be unpaid pre-petition, before the bankruptcy filing, during that 90-day period. That's when the issue of whether it was paid or unpaid comes into play. It doesn't come into play after the 90 days because the whole statute deals with preferences and deals with events that are happening pre-petition. Also, if you're not going to have a cutoff date as the petition date, then when are you going to have a cutoff date? What if Roth got paid 5 years later? Is that going to? Is this trustee going to come back and say that they don't have a new value defense anymore, so they're making that argument as well. So that's the issue. And in the bankruptcy world, it's a contested issue. This is the Court of Appeals again in the Third Circuit. And the Third Circuit finds that it makes more sense to interpret the statute that there is a cutoff, and the cutoff is the petition date, and that if you get paid later for value that you supplied but were not paid for during the preference period, then arguably, not arguably, then it doesn't matter. In other words, it doesn't matter if you got paid later after the cutoff, which is the preference period. The Third Circuit also, or at least bankruptcy courts in the Third Circuit, have addressed also the issue of paid new value, and when paid new value can still be used as new value, even if it's paid during the preference period. But that's another case, or another few cases actually. Well, the court found that the creditor provided unsecured credit by providing staffing services at a time when the business is troubled, and that's how it replenished the bankruptcy estate during the preference period. It's not the job of the court, pursuant to the statute, to look at what happened later. I think between the lines, we're trying to encourage, as a policy, folks from extending credit, especially in a situation where the debtor may be paying very late, maybe there are collection issues, whatever. It's a situation where you want to encourage vendors to extend credit. Why? Because maybe the company won't have to file bankruptcy if vendors act this way. And if you encourage vendors to do the opposite, for example, if these guys, this staffing company lost this one, then the vendors are going to be much tighter. They're not going to want to extend credit because they're going to get sued later. So, so you want to encourage this as a policy. the outset, I have to say that this is a 2007 Massachusetts case. The reason I emphasize the year of the case is because the underlying bankruptcy case was filed prior to 2005, and the prior form of the law applies. The law before 2005, with respect to ordinary course, is that you had to apply both. You had to, the defendant had the burden of showing both ordinary course between the parties and an industry standard. You had to show both. Now you can show either or. So it's a very big difference, because industry standard, depending on which court you're in, can be hard to prove. Debtor was a professional sales outsourcing company that provided sales teams and sales consultants of Boston, was the defendant, and provided essentially a headhunter, provided, I'm assuming, salespeople for the debtor. And this arrangement, the typical arrangement is that the defendant would be paid a percentage of the annual salary of a placed employee. So 1 year prior to filing bankruptcy, and there's a one year look back period here, because the court found that the defendant was an insider, non-statutory insider for various reasons. And so the look back period was 1 year instead of 90 days. Anyway, a bunch of transfers occurred. Trustees sought to recover each one, ouch, as a preferential transfer or a constructively fraudulent transfer. And I'll go into that in a second. The defendant filed a motion for summary judgment, and the trustee objected but did not file a counter motion or a cross motion. Defendant argued that the contemporaneous exchange defense applies, because the intention of the parties is that SCB would provide a new employee, and debtor would pay for and debtor would pay a percentage of the year's wages. So the intention is that it was happened at the same time. It's not a credit transaction, and there were no terms stated in the agreement. What didn't say 30 days, didn't say 30, didn't provide an interest rate for over 30 days, and so SCB argued its contemporaneous exchange. SCB also argued that it was in the ordinary course. We've been doing this over the course of 5 years. We always got paid a commission, and just so happens that 15 of these commissions were paid in the preference period. The debtor argued, well, it's not ordinary course, and this is a constructive fraudulent conveyance. So the debtor argues not ordinary course, not contemporaneous exchange, and also it's a fraudulent conveyance. The trustees arguing the debtor didn't get its money's worth. The debtor got, to put it bluntly, ripped off. And the theory here is that SCB knew that the debtor was, or should have known that the debtor was about to file for bankruptcy, and here they are continuing to place employees with the debtor, and basing their commission fee on a year, when it seems perfectly obvious the employees are not going to last a year or may not last a year, and the commission should have been lower. It should have been a commission based on a much shorter term, given the extreme financial distress and imminent bankruptcy filing of the debtor. So, by the way, the trustee sues for a preference or alternatively a constructive fraudulent conveyance. So the defendant is defending both contemporaneous exchange, ordinary course, and the defendant saying it was reasonably equivalent value. On the preference side, this is the contemporaneous exchange defense. Note, it has two prongs, that there's an intent that the transaction would be a contemporaneous exchange. In other words, not a credit transaction. Services, payment, goods, payment, pretty much right away. No terms. And in fact, it has to be a substantially contemporaneous transaction. In other words, the intent is not good enough. It also has to look like a contemporaneous exchange transaction. It has to be close in the payment and the exchange of value has got to be close in time. 547C, the ordinary course section, we've seen that before. This is the constructive fraudulent conveyance section, 548A1. The trustee may avoid, and I'm going to skip a lot of this, transfer if the debtor voluntarily or involuntarily, BI, received less than reasonably equivalent value in exchange for such transfer, and, that's an and, was insolvent. So both elements have to be there, which is not true for an actual fraudulent conveyance. So for constructive fraudulent conveyance, where you're not looking at bad intent, you're not saying there was an intent to steal or an intent, a knowing and bad faith transaction, you're saying you're not looking at that at all. Maybe there was, but you're not looking at it. You're looking at, did the debtor get its money's worth or not? And was the debtor insolvent at the time of the transfer? It only makes sense if the debtor was insolvent. So why? Why is that requirement there? Because if the debtor was solvent, then who cares? All the creditors are going to get paid in full. Who cares if there was a terrible deal and everyone gets paid in full? It only matters if the debtor is insolvent and someone's getting 100 cents on the dollar in this terrible, allegedly terrible deal before the bankruptcy, and after the bankruptcy, everyone gets bupkis. When I say everyone gets bupkis, of course, I'm not including the entity that was paid pre-petition. Well, the court looked at the contemporaneous exchange defense, and it looked like a promising start to the opinion for the defendant. The court found that, indeed, on the invoice, it stated the payment net due and payable on start date. So there are no 30 days after start date or anything like that. You pay on the start date, and presumably the start date is the transfer of value, because that's when the employee is starting, obviously. So the employee, you get the value, the employee starts, and you pay at the same time, contemporaneous exchange. However, the problem was that the evidence showed that often payments were made well after the specified start date. So here you have an example. Maybe the intent of the parties was that it was a contemporaneous exchange. The problem was, in practice, it wasn't, because the defendant was paid considerably after these employees started work. So that was thrown out. Then the court looked at evidence of the industry standard, because that prong is one of the prongs of the ordinary course defense that here, at this time, needed to be proved by the defendant. And the defendant found that the court found that the defendant was not able to provide evidence that full commissions always be paid. And that was sufficient for the court to throw out that defense. Finally, the court found that there were serious questions as to whether full commissions should have been paid for the placement of employees with the debtor when the defendant likely knew or had reason to believe that the defendant was on the verge of bankruptcy. So this would have been extremely helpful for the defendant, because it would get paid in full when there's a bankruptcy about to be filed, but it wouldn't have been so great for the debtors, either for the debtor or the debtor's unsecured creditors, who will be paying for this full commission on an employee that the opinion seems to be implying will shortly get laid off. Therefore, the court rejected the summary judgment motion of the defendant, and the case proceeded to discovery. That's a general rule. That it's not really a takeaway in this case, but it's something good to know. I'm going to talk again about some conduit cases because this is a defense that's often used and sometimes succeeds, sometimes doesn't in the context of staffing companies. This is TMG Staffing Company. This is a defendant in the bankruptcy case, Cypress Restaurants. Fairly recent case, 2005, bankruptcy level, Middle District, Florida. So Cypress Restaurants of Georgia operated a bunch of restaurants, family-style restaurants, went bankrupt, Chapter 11, and TMG Staffing provided leased employees to the company during its Chapter 11 case. The agreement specified, and this is an important thing to remember, that the defendant would be responsible for wages and taxes due to the employees, regardless of whether the debtor paid the defendant for the employee's services. Not a good contract for the conduit defense. So the defendant demanded wire payments in its provision in its contract with the debtor because it was concerned about getting paid. After all, the company's in bankruptcy. And that concern was obviously well-founded because the Chapter 11 case, the reorganization case, Chapter 11 case, was converted to a Chapter 7 liquidation. So obviously things went from bad to worse. Things got much worse for the defendant because after the Chapter 7 case, the trustee was appointed, and he sues the staffing company for wire transfers during the prior Chapter 11 case. The defendant argued that the transfers can't be avoided because, hey, we were paying taxes and wages to employees that are working at your location. So we were using these funds to pay taxes and wages of the employees. So we're a conduit. You know, we're just a middleman for the funds that you paid us. Went right out, came in the front door, went out the back door to pay taxes and wages. Well, the court shot the conduit defense down and basically said the money that the debtor paid was used to pay the claim of the defendant. It's between the defendant. This is just another debt. And a big reason for that is that the defendant agreed in the contract that it was expressly responsible to pay the employees' lease to the debtor. And the court said this defendant was just a creditor of the debtor and supplied leased employees, but it could have been supplying bananas. Doesn't matter. It's responsible to pay its own debts, and this is just the taxes and the wages is just an expense that it had. That's it. It's not a conduit. Those are a vendor, just typical vendor expenses. And key here was that the debtor was not responsible for any of this. The court also addressed the issue of control, which is very important in conduit cases. And here the court found that the funds transferred from the debtor to the defendant, that the defendant could have done whatever it wanted to with these funds. If it didn't want to pay the employees and their taxes, then it's the defendant's money, and it's the defendant's obligation. So it's not a conduit according to this court. What's important to understand about the conduit defense is that A typical conduit defense is where there's specific instructions to pay a third party. The debtor issues specific instructions and directions to pay a specific third party by the defendant, and that the conduit does not have leeway over this money, and it's not paying a debt to the defendant. It's simply using the defendant as a middleman, as a pass-through, as an agent for the debtor to pay a third party. That's what a conduit is, and it's important to distinguish that. You'll save a lot of time and money in most courts, in many courts at least, by not making a conduit argument, especially when you're arguing that the defendant is being reimbursed somehow to pay its own expenses, and that's a conduit. It's just not going to work, and so you need a lot of discretion to apply this defense. Otherwise, it's a waste of time and money. It's just not going to work. Thanks for watching the video. I've tried to give some examples, as many as I could, of preference and at least one fraudulent conveyance issue in the context of staffing companies. A lot of the issues that come up in staffing companies are issues that come up in any other industry, but some of the issues that come up seem to come up at least more in a more tantalizing way with staffing companies, especially the conduit defense, which can be tempting to use, but it can be dangerous because the facts can make it clear that it's just not going to work in certain circumstances.